Hello and good day. This is the Disability Law Show. I'm John Scholes. He is James Fireman, partner, Samfiru, Tumarkin, LLP, the most positively reviewed law firm in this country, coast to coast to coast. Reaching out to James anytime. It's really simple. The phone number first, 1-855-821-5900, help@disabilityrights.ca. You can email James there and his team and go to another website, free, anonymous, called disabilityquestions.com. The beauty about that one is it's got a searchable database, so you can look for past questions similar or exactly like yours. Save some time, right? Or leave your question there and James and his crew will get on it. And then finally, disabilityrights.ca, just the firm website. Media tab, you can search for our long-running radio show, which of course James is also a host of that as well, so you can tune into that on a weekly basis. But today, 5 things to remember for clients unsure about their legal claim process. Stick around for that, but we always start with a little tidbit, the week that was, a case you're working on, James, or otherwise. What do you got, pal?
Well, I actually wanted to spend my time at the beginning of the show talking about COVID and about long COVID, or long haul COVID, if you will. And so, this is something that we've seen reported in the news, in the media, vastly over the last year or so. People who have been infected with one of the different variants of COVID, and even after the virus is gone, after they're testing negative, they continue to have various symptoms. Oftentimes it is extreme fatigue or overall body pain, things of that nature, which can be very debilitating and really a huge issue for people who are trying to be able to work. If you've got extreme fatigue and if you have trouble getting out of bed because of overall body pain, how are you going to be able to put in a day's work, especially on a consistent basis? And so this is something where we're seeing a lot of people in this situation starting to apply for LTD benefits, as they should. Because COVID or symptoms from COVID are absolutely covered under long-term disability policy. The issue isn't about what is causing your symptoms. The issue is not about what your diagnosis is. This is something that we talk about all the time. The issue is about your symptoms and the impact of your symptoms on your functional ability, the ability that you have to actually do the duties required of your work. And so whether your symptoms are caused by COVID or caused by cancer or caused by fibromyalgia or some other underlying condition doesn't matter. What matters is that you have symptoms that are preventing you from working. And so people who have this condition should apply for benefits. Now, are you going to get approved? I can almost guarantee you won't. I can almost guarantee that if you are applying for LTD benefits because you have long COVID, almost every insurance company I can think of is going to deny your claim, even if you have proof that you initially had COVID. And many people don't, by the way, especially now. There are all kinds of people who have contracted COVID, but there simply isn't testing available right now to determine that you actually contracted it. And so there are all kinds of people that will suffer from long COVID that won't even be able to prove what caused it initially. I say that doesn't matter, and the law says the same thing. What matters is that you have a medical condition that is preventing you from being able to do your work. So where does that leave you? If the insurer is going to almost certainly deny your claim, why bother? Well, the answer is because the way the insurance company is going to deal with a COVID-based claim is very different in the claims process than in the legal process. Okay. And the reason for it makes a lot of sense when you think about it. In the claims process, the insurer is going to deny all these claims. In fact, if the only basis that you're asserting you're disabled is because of COVID, if there isn't anything else that you're relying on as your disability, your insurer will invariably deny that, and they'll say, oh, well, there's no proof, there's no evidence that you remain disabled. They won't say we don't cover COVID. They'll just say there's no evidence that you remain disabled. Because if they were to approve you, even if it's very clear that you're disabled, if they were to approve you, everyone who has long COVID is going to make an application, and they're going to have to start approving a lot more claims than they want to. So they're just going to deny all of these claims out front, and that's what we're seeing happen. Now, once you start a legal claim, that calculus changes, because the one thing the insurance companies do not want is to have a decision decided by a judge in court that says people who have long COVID and continue to be disabled from it are entitled to benefits. As soon as that happens, as soon as there is a case that reaches a court and a judge has to make a decision, if the judge determines that long COVID is in fact something that you would be entitled to benefits if you remain disabled, that's going to get very vast media attention. That's going to be reported in all the media outlets. It's going to be reported nationally in television, newspapers, if they're still in print, what have you. That's something that is going to get a lot of buzz, and all of a sudden, everyone in Canada who has had COVID and continues to suffer ongoing symptoms that they believe are preventing them from being able to work is going to start a claim. And now the insurer is in a position where they can't just deny it. They can't just say, oh, well, we don't see any evidence of it. If the court is saying someone who has long COVID that can show that they had COVID and continues to suffer from it is entitled to benefits, they're in a very bad position. And so what does that mean for the insurance company when they're faced with a legal claim? All of a sudden, even though they're never going to approve the claim when you apply, as soon as you bring the legal claim, all of a sudden they become very reasonable and they want to resolve those claims very quickly. They do not want them coming anywhere near a court, because if it does, they're in big trouble.
So their opening salvo, their first defense is denying the claim off the top and hope you go away.
Absolutely.
They don't watch the show, they don't wise up and call you. That's what they're hoping for.
Absolutely. And the reality is, unfortunately, that most of the time that works. Most of the time people don't take the next step and pick up the phone and give me a call, or one of the other lawyers in my firm a call, because the reality is if they did, then they're going to be entitled to get a lot more than if they just sort of try to appeal or accept the decision of the insurer.
With that term that we often talk about on the show being totally disabled, is that what's going to throw a lot of people too? Because long COVID, you may be, again, suffering from fatigue or other things from the results of COVID long term, but you may not be what you would think is totally disabled.
It's an excellent question, John. So in a standard long-term disability policy, the language in the policy is going to say that in order to be entitled to your monthly benefits, you have to be totally disabled. Totally disabled is defined in the policy. All it means is that you suffer from a medical condition that is preventing you from being able to do the essential duties of your job. You are suffering from a condition that's preventing you from working. Right. It doesn't mean that you are totally disabled in the sense that you can't get out of bed. It doesn't mean that you can't bathe yourself, or you can't feed yourself, or you can't go to the toilet by yourself, what have you. It only means that you're not able to do your job. And so if that is the extent of your disability, you are able to do some things for yourself, but you are still not able to do your job. And being able to do your job, by the way, doesn't mean that you could do it for an hour. It means that you have to be able to reliably show up for work, even if it's working from home. It means you have to reliably be able to work a full work week. And if you are suffering from extreme fatigue, how are you going to do that? Right. It's just not something that most people are going to be able to do. And so they use this term, totally disabled, as a way to discourage people from continuing. They say, you're not totally disabled. And most people read that and they say, oh, well, I guess that's true. I mean, I can do some things for myself. And so I guess maybe I'm not entitled to this claim. Right. Don't buy it.
The moral of the story is reach out if you have any doubt, right? 1-855-821-5900 to get hold of James and his team, help@disabilityrights.ca. And there's also another website I did mention, mydisabilityquestions.com. It's free and anonymous, yet another way for you to reach out, ask some questions, get some answers, because we know it can be confusing. First one for today, James, comes from our pal Lucas. He says, my insurance provider started pressuring me to go back to work after being on LTD for nearly 2 years. That's coming up. I resumed work after they set a cutoff date for my benefits. Unfortunately, the same health issues I suffered from before started to resurface. What are my options?
So the first thing, Lucas, that you really need to understand is how the policy works in this situation. Right. So when you are approved for LTD benefits, if your situation improves, if your disability starts to get better to the point where you're able to go back to work, almost every policy I've seen has what we refer to as a recurrence clause. What that is a provision in your policy that would allow you to attempt to return to work once you're on benefits. And if that attempt is unsuccessful, if you're not able to continue because of the same disability that entitled you to benefits in the first place, then after attempting to return to work, you should be entitled to resume getting your benefits, which means you don't have to go through the application process. You don't have to go through that 3, 4, 6 month elimination period before you're entitled to your benefits, which is great if the insurance company actually abides by it. Unfortunately, more often than not, they don't, as seems to be the issue here. And so really what you want to make sure, first of all, if you're in this situation, you want to make sure that you're dotting your I's and crossing your T's before you attempt to return to work. And so what that means is making sure that you run this by your treating doctors, whether it's your GP or if you have specialists, make sure that they're looking at it as well. And what you want to do is you want to look at what the return to work plan is. Are there limitations and restrictions that are being suggested? Is there a return to work schedule? And you want to run that by your doctors and specialists. If your doctors and specialists say it's okay for you to try, as long as you abide by these restrictions and these limitations, and you do it on a gradual schedule where you're limited in the number of hours and days initially, and over several weeks that will increase until you're full time, that's fine, as long as you got approval from your doctor. But if when you put that to your doctor is saying, no, you're not ready to return to work yet. You need to have more treatment, or you need to show more improvement before there's any reasonable chance of success. Or if you try and return to work now, you're actually likely to do something that's detrimental to your health. In either of those situations, if your doctors aren't telling you that you are medically fit to return to work, then you shouldn't be doing it. If your doctor is saying that it's okay to try, then by all means, if you feel ready to try, you absolutely should. And hopefully you'll succeed, because the reality is, if you're able to return to work and get 100% of your benefits, that is way better for you than trying to get 2/3 of your benefit from your insurance company. So there's no question that it's better for you if you're able to improve sufficiently to return to work. But make sure before you do that you've gotten approval from your doctors. If you're in the situation where you've already attempted and you weren't successful and you tried and go back on, as is the case with Lucas here, and your insurer denies you, well, then your option is to start a legal claim. And that's really, the way around it here. You start a legal claim and you force the insurance company to come to the table. And wouldn't you know it, as soon as you do, far more often than not, they're going to be very reasonable very quickly.
5 things to remember about the legal claims process. That is where we're going, but we're going to do it after break, so stick around for more. Disability Law Show is coming right up.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Alrighty, welcome back. Disability Law Show continues. John Scholes here alongside James Fireman, partner, Samfiru, Tumarkin, LLP. You want to reach out anytime to the most positively reviewed law firm in the country. 1-855-821-5900. Let's get to this, James. Get through these 5 points. Things to remember for clients unsure about the legal claims process. Number 1, we talked about this before. Once a legal claim is filed, claimants no longer need to deal directly with the insurance company. A breath of fresh air for most people who don't know.
Yeah, absolutely. So the first thing that we do as soon as we start a claim is we send a letter to the insurance company saying that we've been retained by this person. From that point forward, the insurance company has to send all communication to my office directly. They are no longer entitled to call you, they can't email you. So to the extent that's causing stress and anxiety, that ends the moment you sign the retainer, and that's a pretty big relief for a lot of people.
Big time. Number 2 is this. Filing a legal claim permits clients to focus on their treatment and recovery, which is the whole point, right?
Right. This dovetails exactly nicely with what we were just talking about there. You're not going to have to worry about fighting with your insurer anymore. Now your focus is simply on whatever treatment and rehabilitation has been recommended by the doctor. Now, I'm not going to go so far as to suggest starting a lawsuit is good for your health. I will stop myself short of that. But what I will say anecdotally is I have heard from countless clients that starting the process and no longer having to deal with the insurance company, taking that off their shoulders and putting it on mine, is instant relief of stress and anxiety. And in a lot of cases, I believe that at least plays some role in allowing them to improve. And I certainly have many situations where someone comes to me, especially with mental health claims, where they are in just a very bad position, where their mental health is just nowhere close to being good enough to be able to return to work. And when you know it, we get a mediation 8 to 10 months after the retainer is signed, but before we ever get there, they're able to return to work. And I honestly believe a big part of that is offloading the stress and anxiety of having to deal with the insurance company. I'm not going to tell you that that's why. I'm not going to tell you that that is more effective than the therapy and the treatment that they're invariably getting. But it does play a role. It certainly does help. It allows you to focus on what is really important, and that is very useful.
You're unsure about that legal claims process. These are the points we're hammering through, and that kind of speaks to number 3, and that is if your disability improves during the legal claim, you can return to work, because people often don't know what happens if I start getting better. I'm in the middle of the process.
Yeah, that's a really big misconception. People believe that if you start a legal claim, if you're fighting with your insurance company, you hire a lawyer, then until you resolve it, you can't go back to work. And I'm sure there are some lawyers out there that are telling their clients that, but you're not going to hear that from me. None of my clients will ever hear that. In fact, I tell every single one of my clients in the initial interview, when we're talking before they've signed a retainer, I tell them very clearly that once you start the legal process, if you get better and you're able to return to work, then that's the best thing for you, and you should return to work. And let's say we have a mediation scheduled for 3 or 4 months down the road at the point they become good enough to return to work. Well, that doesn't mean they no longer have a claim. All it means is that their claim has become more modest. We are no longer looking at getting their benefits for up to the date of the mediation and for several years into the future. Now we're just looking at the benefits from the point where their benefits were cut off until the time they return to work. That is a more modest claim, and usually something we can resolve without even having to go to the step of going to mediation and taking a whole day to do that.
Well, I mean, it's like you said before on past shows, would you rather earn the 65% that you're getting on disability or get back to work when you can and get 100%?
Absolutely, and that's an easy decision for any client.
Yeah, exactly. Point number 4 is this: it is extremely rare for a legal claim to progress to a courtroom. Again, the reason why so many people hesitate making a claim. They don't, they're picturing American TV, right?
Yeah, this is a really big misconception, but it's understandable.
Yep.
Because for the vast majority of people, all of their interactions with the insurance company suggest that the insurer is intransigent. They're never going to move. They're never going to pay. But the reality is the insurers remind me of my 6-year-old daughter. Now, she's the light of my life. I love her with all of my heart. But she can also be pretty unreasonable until she knows that there is a consequence to her actions. When I tell her, listen, sweetheart, if you keep doing that, you're going to have to go to your room, all of a sudden she starts listening very closely. Well, it's the same thing with insurance companies. When you start a legal claim and if you're not being reasonable, you're going to wind up in front of a judge, wouldn't you know it? All of a sudden, the insurance companies are very reasonable, and they want to come to the table and get it resolved because they know there's a consequence if they aren't reasonable. Before you bring a legal claim, they can do whatever they want, and there is no consequence to it. So that is a huge factor. And once you start the process, they're going to come to the table, and the odds of actually having to go to trial are exceedingly low.
Again, these 5 points, we'll get to number 5. If any of these are confusing, you want more information, you can always reach out anytime to James at 1-855-821-5900. Fifth one is this: our disability lawyers, your disability lawyers, work on contingency, meaning no legal fees up front or during the legal process. That's huge too.
Yeah, it's really important. So we get paid a percentage of what we recover at the end of the case. And the reason we do it that way is pretty obvious. Our clients are people who are not earning an income anymore and are not receiving any benefits from their insurance company. And so they're not able to afford to pay an hourly rate to a lawyer in order to go after the insurance company. So that's really the only way that we can work it so that it makes sense for both sides. But the added benefit is it makes sure that the interests of our client and our firm are always going to be aligned. Because we get paid a percentage, our clients always know that our interest is in getting as much from the insurance company as possible. The more the insurance company pays, the better we both do. And they also know that because we don't get paid anything unless we're successful and until we actually get money from the insurance company, they know that all of our efforts are to trying to get the case resolved as soon as possible. We want to get as much as possible as soon as possible, which is exactly the interest of every client I've ever had.
Also shows that you're not just casting a net, taking everybody off the street. I mean, if there's something at the end of the rainbow, that's rest assured for the client too.
Yeah, that's the trick right there. That is, I would say, probably 80% of our job is making sure that the clients that we're retained on are clients that have legitimate disabilities.
Yep.
You know, there is a huge part of it after that, but if we are not really careful about the clients that we take on, we're going to be spinning our wheels in a situation where there's no point, where, you know, a year down the road you realize that there's no claim there. So it's something that we take a lot of care in the initial interview process to make sure the clients we're taking on are legitimately disabled and have a claim and that they're entitled to benefits.
Again, reaching out anytime as we get to a quick break here, 1-855-821-5900, help@disabilityrights.ca. I mentioned disabilityrights.ca, the website as well. The media tab, find a radio station near you that carries our show. We'll get to a phone call from one of those after the break. Stick around.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
Alrighty, welcome back. Disability Law Show. As I mentioned just before the break, we do a long-running radio show, and it's all over the place. You just want to go to disabilityrights.ca, media tab, find a station that carries the show near you. They're generally an hour long. James hosts a ton of them, a ton of information. People call in all the time and ask questions. So we wanted to get one of the phone calls from the radio show we thought was interesting and dissect it a little further here. So it's coming up right now, James.
I actually did get approved for long-term disability in February. At the same time, I did sign off on a release that said income declaration and reimbursement, and I thought it was because I'm not getting any other income. They're now asking me, because I'm eligible still, to apply for CPP Disability. Is that normal?
Well, that's a really good question. This comes up all of the time. And the reason is virtually every policy is going to have language in there dealing with CPP disability. So let's just take a step back for a second and make sure that we all understand what we're talking about here. So if you have been paying into CPP, the Canada Pension Plan, if you have been paying for, I think it's at least 4 of the previous 6 years, and you become disabled, you're entitled to apply for CPP disability. This requires that you have a severe and prolonged disability. So if you pass that test, CPP will actually start paying you monthly benefits. I believe this year is up to about $1,400 is the maximum that they would pay per month. And so if you're approved for that, the very nice thing is, even though you're not working and you're not continuing to pay into CPP, it counts towards your CPP when you turn 65. So that's a really nice thing, and you're getting that monthly benefit. Now, if you're also getting long-term disability, unfortunately, it doesn't add to the overall amount of money that you're getting. So, for example, if you were getting $1,000 in CPP and your monthly benefit was $4,000 a month, now what happens is your insurance company is entitled to take a credit for that CPP disability payment. And so instead of paying $4,000 a month, they're now deducting that $1,000 from CPP disability. And if my math is correct, that means they're paying $3,000 a month. And so that's pretty straightforward. And so you might be thinking, okay, well, why would I bother applying for this if at the end of the day I'm not further ahead financially? Well, first of all, I've already given you one reason.
Yep.
It makes sure that your CPP contributions are still made while you are on CPP disability. That's number one. But number two, you should do it because you're required to under your policy. If you don't apply for CPP disability at your insurer's request under the policy, then what will happen is at some point the insurer is going to say, if you had applied, you would have been approved, and we're just going to estimate what you likely would have gotten and deduct that from your monthly benefits. So by applying, you ensure that doesn't happen. Either by applying you get approved, in which case you're still in the same position, you're not getting less at least, or you get denied by CPP disability, in which case the insurance company isn't in a position to say you would have been approved. Either way, you're at least not falling behind, which you will if you don't apply. So that's a really good reason to do it. The other nice thing, though, is if you are approved for CPP disability, because the test for CPP disability is a more onerous test than the typical LTD disability test. If you're approved for CPP disability, it makes it very, very hard for your insurance company down the road to say, oh, well, you're no longer disabled under our policy. You no longer pass that test if you continue to pass this severe and prolonged test under CPP disability. And even if they do, even if your insurance company is foolish enough to cut off your benefits while the government has said you have a severe and prolonged disability, at the very least, while you are in the process of starting the legal claim and challenging your insurance company, you're going to continue to get those CPP disability benefits on a monthly basis. So you're at least going to have some money coming in. And if you do have to challenge your insurance company, you're only challenging them for the monthly benefit reduced by the CPP disability, which means that if you have to hire a lawyer, the legal fees are going to be based on a smaller amount, so you're going to save some money there as well. These are a lot of very good reasons to apply for CPP disability if you are in the LTD process.
Let's move on to an email. This from Devin writes in, says, I was approved for long-term disability because of my fibromyalgia. After sending me for an assessment, my insurer's doctor says I need different medication. My own medical team says the recommended medications will help in the short term, but could have serious long-term side effects. Because I refused the medications, my benefits were cut off as I'm, quote unquote, not compliant. What do I do?
We bring a legal claim. There's no two ways about it. What the insurance company is doing here is it cannot be justified. So you are required to take reasonable steps and to adhere to any reasonable recommendations for treatment. But that doesn't mean that anything that might temporarily improve your situation, you automatically have to accept and follow through with. In other words, if there was, some narcotic drug that can get you past extreme fatigue and allow you to be able to work for, 2 or 3 months, but in the long term, obviously, it's going to have debilitating impact on your health. Obviously, you're not required to do that. Now, that might be an extreme version of what's happening in Devin's case here, but you are absolutely entitled to consider your long-term health and make a reasonable decision based on that. And if your doctors are telling you that this particular medication is wrong for you for whatever reason, either just because in general it is something that has serious long-term effects, or perhaps it would have a bad reaction to other medications that you're taking, or you're just not suited to it because of other conditions that you have, whatever the situation is. If your own doctors are telling you that this is not an appropriate medication for you, then you shouldn't be taking it. You absolutely should be listening to your doctors in all cases for any medical decisions, and certainly what medications you're taking is a medical decision if ever there was one. So if your insurer, as has happened to Devin here, cuts you off because they say you're non-compliant because you refuse to take a medication your doctors are telling you not to take, you have to bring a legal claim. And guess what? If you do so, if we start a legal claim in this type of situation, the reality is that the insurance company is not only going to have to pay those benefits, but they're going to be in a position where they're likely going to have to pay damages on top of that, because they are not allowed to force you to take things that are bad for you. That's general damages and probably punitive damages on top of that as well. And as soon as you bring the legal claim, this is something we've already talked about in this show, as soon as you bring that legal claim, they're all of a sudden going to get very reasonable. And part of the reason that happens is it moves from the claims department to the legal department. And once that happens, they know what's going on and they know that they're going to have to pay.
And that will do it for another day. James, awesome as always. You want to reach out now that we are through, 1-855-821 5900 help@disabilityrights.ca, and mydisabilityquestions.com is free and anonymous as well. And thank you for joining us. We'll catch you next time on the Disability Law Show.